Good day, my name's Hugh Reed. I'm the CEO and founder of Reed Bar Review, and I'm going to give you some mnemonics today and memory devices for impeachment evidence, obviously. The Federal Rules of Evidence, drafted in the late 70s or thereabouts, made some changes to the common law, but your discussion in evidence should always start with relevancy. That is, the Federal Rules of Evidence, specifically Federal Rule 401, will say that all evidence is logically relevant if it introduces some evidence that makes a fact of consequence more or less probable. I'm paraphrasing, obviously, but it's a fact of consequence more or less probable. And then we say, well, just because evidence is logically relevant, it also has to overcome the threshold of legal relevancy. That evidence that's logically relevant is legally relevant unless the probative value is substantially outweighed by the prejudicial effect. So another way of paraphrasing that is, all evidence that's logically relevant will probably come in unless there's a whole lot of darn prejudice, all right? But look for the word substantially outweighed for the prejudicial effect. And then if you check 403, it will tell you that the reasons why evidence may not be legally relevant are darn crash made us wait cautiously. It stands for danger of unfair prejudice, crash, confusion of the issues, made, misleading the jury, us, undue delay, wait, waste of time, cautiously, cumulative evidence. And then even though evidence is logically relevant, it's legally relevant, it may not be relevant because some of the policy exclusions under Federal Rules 407 through 411, such as liability insurance to prove up negligence, such as offers of compromise, such as guilty pleas. So make sure that you understand evidence has to be logically relevant, legally relevant, and is not precluded from admission because of some policy exclusion. All right, well, let me give you impeachment. Peter beat Paul silly on Saturday. So what does that stand for? The first P stands for prior inconsistent statement. Beat stands for bias or prejudice. The second P stands for prior convictions. Prior convictions. Silly stands for specific bad acts. Specific bad acts. Something short of a conviction. On stands for opinion and reputation evidence. Opinion or reputation evidence. Reference truth or veracity under Federal Rule 608. And then Saturday stands for sensory deficiencies. Sensory deficiencies. Like the little old lady on the stand who had glasses this thick in My Cousin Benny. Sensory deficiencies. So Peter beat Paul silly on Saturday. Now, let's start filling those out a bit. First of all, Federal Rule 607 says that any witness on the stand can be impeached. You can impeach your own witness, all right? So anybody can be impeached. Then the federal rules do not use the term collateral matters, which was something under the common law, but collateral matters are inferred by the federal rules. In other words, whatever you ask should be germane to a point, an issue at trial. All right? So it should be something that if you make a prior inconsistent statement, for example, which is our first P, then impeachment is not proper unless a foundation has first been laid by asking the witness whether he or she made the prior inconsistent statement. and is given an opportunity to admit or deny it. And that's Federal Rule 613. So look for whether the witness was cross-examined. So let me give you an example. Let's say Bubba is out driving drunk, and unfortunately, he strikes a pedestrian, and he leaves the scene of the accident. He goes to the nearest bar where his brother-in-law is the bartender, and he says, "Set him up, Charlie. I think I just hit someone and I left the scene of an accident. And by the way, that wife of yours, or the wife of mine, the sister of yours, I regularly beat her up because I don't like the way she objects to my drinking," or something like that. Well, anyway, a year later, he's being charged for hit and run. Can we get his brother-in-law on the stand to talk to us about what the driver of that vehicle said that evening? Because now he's saying, "I didn't do it." Of course we can. That's important. That goes to the crux of the matter. Can we try to paint the defendant as a bad character because he beats his wife every night? Can we ask the bartender about that? The answer is no. Because what we're talking about, the beating, is a collateral matter. It's not an issue at trial, okay? So that's how you got to look at prior inconsistent statements. And by the way, it does not have to be under oath. It can be to the bartender, but it has to be important to what we're talking about. And they're admitted only for impeachment. They are not admissible as substantive evidence unless the prior statement was made under oath, under 801, Federal Rule 801. So we're trying to destroy the credibility of the witness on the stand, prior inconsistent statement. All right, prior consistent statements, by the way, may not be used to buttress a witness's testimony or bolster a witness's testimony. Prior consistent statements may not be used. They can be used only after cross-examination, which has suggested the witness has had some reason to fabricate an answer, and that's under 801D. Prior consistent statement in order to refute a charge of recent fabrication. So anyway, the first P is prior inconsistent statement. Collateral matters, I said, are not allowed, and that's Federal Rule 1004. Only matters that are germane or that are important to issues on trial. Beat, bias, or interest. Every witness who takes the stand may be impeached for truth and veracity, and for any bias that he has. So it's the witness who takes the stand, who's the insurance salesman for the car insurance that insures the defendant's car. Well, clearly he has an interest, he's biased, and for impeachment, those persons can never be rehabilitated, whereas other witnesses who've been impeached can be rehabilitated in most instances. But for bias or interest, you cannot rehabilitate them. All right? So Peter beat Paul. Prior convictions under Federal Rule 609. Prior convictions work like this. I'll give you the short version. First of all, every witness on the stand can be impeached for a conviction having to do with truth or veracity. That is, a conviction for embezzlement, falsification of tax returns, even plagiarism, a misdemeanor. So you can impeach for prior convictions having to do with truth and veracity. Any witness, including the defendant. What about for a conviction other than having to do with truth and veracity. Well, then the federal rules, specifically Federal Rule 609, says it has to be a felony, and we have different rules for a regular witness and the defendant, if the defendant takes the stand. If it's a regular witness, the judge has to apply the legal relevancy rule under Federal Rule 403. That is, am I going to allow it in? Well, is the probative value substantially outweighed by the prejudicial effect? And if the probative value is substantially outweighed by the prejudicial effect, I'm not going to let it in. So another way of saying it, it'll probably come in if it's logically relevant, unless there's a whole lot of darn prejudice. What about if the defendant takes the stand? Well, it's a harsher rule. And we say that it's probably not going to be allowed. A past conviction will not be allowed. So if he's been convicted of larceny, burglary, some other crime not having to do with truth and veracity, it'll probably not be allowed unless it's more probative than prejudicial. So we leave out the word substantially. And what kind of instance would that be? Well, let's say the defendant's charged with robbing a Piggly Wiggly at 3 o'clock in the morning with an Obama mask on, with a shiny snub-nosed revolver, and he stutters as he speaks to the cashier, open this register, right? He has a stutter. Well, he has 2 or 3 other convictions with exactly the same MO under MIMIC, M-I-M-I-C, under Federal 404B. He has the same MO. In this instance, it would be more probable than not that he committed this particular robbery. So that's how it works. Prior conviction. Now, there's some other rules under 609 that you have to know. The 10-year rule. That is, any prior conviction has to be more than 10 years old. However, there's ways to get around that. If you intend to use it, you can give the other side notice in writing that you intend to use that. Juvenile convictions obviously cannot be used for impeachment. And the 10-year limit is something that you should really know. So juvenile convictions, any kind of annulments cannot be used. However, matters on appeal can be used. All right. So 609 has a whole bunch of rules. Generally, a couple of questions on the multi-state bar exam having to do with 609. Pardons or annulments cannot be used. Juvenile convictions cannot be used. All right. So Peter beat Paul silly. Specific bad acts. Let's talk about specific bad acts. Anything short of a conviction, you can impeach someone with a specific bad act. However, there is a highlighted rule that you should know about. If you ask a question and the defendant or the witness denies the specific bad act, something short of a conviction, you're stuck with his or her answer. Let's say you know the witness cheats at cards regularly. You've got 100 witnesses outside the courtroom waiting to testify that he's cheated at cards. And you ask him, isn't it true you cheated cards? Therefore, you're not trustworthy. And the witness says, no, I don't. I'm a choir boy. Well, unfortunately, under the federal rules, you're now stuck with his answer. You should have, if he was important enough, you should have gotten other witnesses to testify with reputation and opinion evidence. But if you ask a specific bad act that this witness allegedly committed, you are stuck with his answer under the federal rules. So Peter beat Paul silly on Federal Rule 608, opinion and reputation as to truth and veracity. You can always admit opinion and reputation evidence as to truth and veracity of a witness if he's an important witness. You can get somebody else in saying, what's your opinion? What's his reputation? All right. Opinion reputation evidence, there are some restrictions that as it applies to the defendant. But if the focus of your interrogation is truth and veracity, you can get in opinion and reputation evidence on cross-examination. Obviously, we can ask about specific bad acts, but only if you preface the question, have you heard or do you know? And then you can talk about specific acts, right? Specific acts having to do with truth and veracity. And then finally, Peter beat Paul silly on Saturday sensory deficiencies. Any witness can be impeached with regard to sensory deficiencies. Again, the little old lady on the stand with the judge helping her, and My Cousin Vinny, if you remember that movie. Obviously the judge can't help her. That was the whole idea. But if someone claims he saw something, he saw two young men coming out of a grocery store at 50 yards, and they can't see 3 yards in front of their face, or they have some other sensory deficiencies, you can impeach that witness with that sensory deficiency. All right, let's review. What are we talking about? We're talking about impeachment. We can impeach any witness who takes the stand with regard to his or her credibility, including your own witness. We cannot bolster witnesses' truth and veracity before it's been attacked, right? We can impeach with 6 major areas. Peter beat Paul silly on Saturday. Prior inconsistent statements. Bias or interest. Prior convictions under Federal Rule 609. Specific bad acts. Opinion and reputation evidence as to truth and veracity. And finally, sensory deficiencies. Hope that's helpful. But that's the way I remember how we can impeach someone. And if you need more help, feel free to register an account on readbarreview.com. Pick out a course, and we'll be glad to help you with any of the courses listed there that you can pick out and get the flashcards, the outline, the lecture, everything you need to get better at whatever you're training for. Thank you.